Good afternoon, everyone. Welcome to this BIICL seminar, the seminar on the topic, broad topic of collective redress. This takes part of our series of seminars dealing with group actions, collective redress, and class actions, which you looked at different themes over the years. And this seminar, we're delighted to be looking at the issue of mass data breaches. We had a seminar just over a year ago, probably one of the last seminars in situ before the pandemic in March 2020, when we looked at this issue from a predominantly domestic perspective. And what we've decided to do today is go beyond that, to look at the UK, but also some key jurisdictions from a comparative perspective in Europe. So we're delighted to be able to bring together a sterling panel chaired by Anya Proops QC, who I will hand over to now, who will be taking us through the seminar. Thank you very much, Anya.
Thank you so much, Duncan. Well, I'm absolutely thrilled to be chairing this webinar on UK-European perspectives on damages claims in respect of mass data breaches. Of course, over the last year in the UK, we've seen this tremendous explosion of class actions in the privacy field. And that's what, of course, makes this seminar so incredibly timely. For me, there are two really important issues which I hope and expect this seminar will help us to explore. First of all, how does the UK compare in terms of its approach to data privacy class actions? How does it compare with the approach that's taken within Europe? Are we seeing the UK shaping up to be the data privacy class action capital of the universe? As some might say, it is fast becoming, or are we actually to be judged as being a relatively conservative jurisdiction when it comes to privacy class action, certainly when compared with what's happening across the channel in Europe? Second, and relatedly, hugely important, what is the direction of travel for data privacy class actions here and abroad? Are things only going to get worse for controllers as time moves on in terms of exposure to these sorts of actions? Or are we actually going to see the courts and indeed perhaps the legislators also seeking to rein in these types of action for fear of their crippling impact on controllers and indeed on the wider economy? So I think it's those issues that we're going to be exploring today. Turning to our panel, we have a truly dazzling array of speakers from across the UK EU East. I'm going to start with Maria José Azar-Baud, terrifying list of achievements. Maria José is an associate professor at the University of Paris-Saclay. She is head of the Observatory of Group Actions and Other Forms of Collective Redress. Her PhD thesis focuses on collective redress in consumer law, and she's one of the main authors of the study on the state of play of collective redress in Europe, which was a document requested by the European Parliament, something that I obviously should be reading. Former lawyer at the Bar of Buenos Aires, she's currently a lawyer at the Bar of Paris and has seats at the board of 2 European non-profit organisations seeking as plaintiffs to grant access to justice on a collective scale. She's been heard as an expert on the French Senate and Assembly, several ministries, as well as in the European Parliament on representative by the time of the discussions of the representative actions proposal of the directive. So without further ado, could I hand over to Professor Maria José Azar-Baud?
Thank you very much. Let me start by thanking the British Institute of International and Comparative Law, Duncan and Anya, for the invitation to participate in this very interesting and challenging event. Interesting since it regards collective redress, which means a way to enhance access to justice, and challenging since damages claims approach, particularly in the field of data breaches, at an early stage and currently under critical scrutiny from scholars, organizations, practitioners, and judges. Recent scandals have unveiled privacy concerns in France, as in many other countries, and triggered the debate on the need to protect personal data. The turnover of data infringements being often incredibly profitable for the infringer, stopping data breaches through the most efficient orders to seize cannot be considered enough. Hence, there is a necessity to envisage other tools, such as compensatory collective redress. In 2014, France has adopted a sectoral collective redress approach. A particular opt-in group action was then enshrined within the consumer code provisions before moving step by step to other sectors such as health, environment, discrimination, and data protection, both before the judiciary and the administrative courts. All the different group actions share common features, which would have justified a uniform legislative treatment. Nonetheless, the lawmakers have built a taxonomy based on specifics per scope, so that rules for damages claims in the data field are to be found within the Code of Civil Proceedings and within the French Data Protection Act, and it is implementing decree having transposed, namely, the European Data Protection Package, consisting of the GDPR and the so-called Law Enforcement Directive. I propose now to describe the main features of the data-related group actions, then the proceedings, and last, other forms of collective redress in France. What are the main traits of the group actions? Data-related group actions aim to protect rights that are homogeneous and individual. They belong to natural persons, in our case, victims of infringements of their personal data rights. Hence, they seek the enforcement of rights contained in the French Data Protection Act, namely the right of information, opposition, access, rectification, and communication of personal information contained in digital files, as well as the possibility to exert those rights electronically. According to the type of personal data violation, the group shall be limited to identified or identifiable natural persons or their heirs who must be in a similar situation. Thus, the group action lawsuit does not benefit legal persons, even if group and political parties are granted a right of access within the French Data Protection Act. The damage must arise out of the breach of legal obligations and contractual provisions or contractual provisions by the controller or the processor of personal data, be it a private or a public person. The infringement needs to be based on common grounds and should have been caused identical or similar individual damages. Standing to sue is restricted to 3 types of organizations: registered associations that we call associations agréées in the consumer field, approved associations having existed for 5 years, if their deeds relate to the protection of privacy and personal data, and to representative trade unions if the beneficiaries are employees or civil servants. The remedy to be sought was initially limited to the cessation of infringements, but a reform has enlarged the scope to the compensation of both material and moral injuries, provided that the facts took place after May 24, 2018. Therefore, the request must be either compensation or cessation, and can be both. The request must be accompanied by model cases on the basis of which the decision will be granted. How do the proceedings develop in France? In a nutshell, the proceedings can be described as follows. Before seizing a judge, the parties having standing to sue must address a prior formal notice to the person allegedly liable to seize the infringements and or to compensate damages. Then a period of time of 4 months needs to be observed so that the recipient seizes and or compensates on a non-judiciary basis. Only in the case of a negative answer or after the expiration of the said delay, the action can be introduced before the judiciary. In the first stage, the judge scrutinizes both the admissibility of the action and the merits of the case. The admissibility, recevabilité, is related to 4 requirements: the right to sue, standing, the fact of having a personal interest, the case is not precluded by the statute of limitations, nor by the res judicata. As for the merits, the classic 3 liability requirements must be met. That means a fault or a non-performance of a contract according to the cause of action, a damage, and a causal link between the 2. only if the defendant is held liable, a publicity stage will be triggered at the cost of the defendant so that the members can opt in. The compensation will then proceed according to the so-called individual compensation procedure. It means that members willing to join the group must address the application to the plaintiff or to the defendant, who then proceeds on to individual compensation according to the extent of the individual damages. Members whose applications have not been acknowledged must refer the matter directly to the judge who ruled on the liability, or to the association if they had addressed the application to her on the first place. Up to date, in total, 27 group actions have been reportedly been brought before the courts, most of them in the field of consumer law, and only 2 group actions regard data protection. One brought by the NGO Internet Society in 2018 against Facebook for non-compliance with the GDPR. The association claims 100 million euros, the case is pending. The other action was filed by the association Université in 2019 against Google on the grounds that the consent of users was not obtained in compliance with the GDPR. The association claims 1,000 euros per consumer having a Google account. Taking into account the specifics of the French system, that is to say, the double degree of jurisdiction, judicial and administrative, the French lawmaker has enacted a group action to be brought before the administrative courts as well against the state or a public service concession holder, namely in the field of data, within the rules of the Code of Administrative Justice. Other forms of obtaining redress, collective redress, different from the data group action, include a joint collective action. It is based on mandates, and it is provided for within the provisions of the French Data Protection Act, according to Article 80.1 of the GDPR. The requirements to engage this joint collective action are less rigorous than the group action, because neither the registration requirement nor the 5 years of the existing condition are required here. They can seek both an injunction and compensation for the mandators. This joint collective action can also be brought before the French Data Authority, the CNIL, who is the French member of the European Data Protection Board. The CNIL will investigate the case and apply fines if needed, but it cannot grant compensation. 7 actions of this type have been brought so far before the CNIL. One of them was engaged by None of Your Business and La Quadrature du Net, and this concerns Google for several breaches regarding users of Google services. The company was fined 50 million euros by the CNIL, who could handle the case directly in France, since unlike other GAFAMs, Google had no headquarters in Europe and could therefore be sanctioned in any country. It is noteworthy that in the middle of the process, Google set up headquarters in Ireland, and then the CNIL, the French authority, had to transfer the compliance to the Irish authority. The second joint action is against Apple, filed in 2018. The French authority has translated it into English and sent it to the Irish counterpart. This Irish counterpart, of course, coordinates the proceedings, has opened investigations and requested additional evidence. The third joint action involves Facebook and LinkedIn, and it is the same old story as in the claim against Apple. The fourth is against Microsoft, and the fifth against Amazon. To conclude, one may say that France is immersed in a learning process, and some lessons can be drawn up. NGOs have to properly choose the appropriate member state authority if they are willing to bring an injunction, collective action, or if they're seeking a fine. They act on the basis of a mandate known and not on their own behalf. Therefore, they have to prove the identity of their members, because this is the ground on the basis of which two of the actions have been traveling from France and Ireland many times. They must also support the claim with evidence related to people who still have the accounts in force. And none of the said actions have been filed before judges for compensation. Thus, without proper scheme of the legal profits, the infringers have no motivation to modify their behaviors. The simplest conclusion could be to say that it still is cheaper to infringe than to comply.
Really interesting. Thank you so much, Maria José. Moving on to Adam Rose. Adam is head of data protection at Mishcon in London. He has had some 30 years experience in this field, though you wouldn't know it to look at him. He looks about 25 to me. He specializes in data protection and freedom of information, and also advises clients on IT and commercial contracts. He advises data subjects, controllers and processors with clients across a number of different sectors, but in particular financial services, retail and leisure. He advises clients on regulatory compliance, transactions and litigation. And his wider team advises on international data transfers, including BCRs, PECA and investigations. Adam, over to you.
Anya, thank you. I'm going to try and set out in headline terms the nature of the claims that could be made in the English courts following a mass data breach. And it will take me it's taken me 30 seconds to mention Brexit, but bearing in mind post-Brexit, when I speak about GDPR, I really mean the UK GDPR, the retained law version of GDPR, which is almost exactly the same as GDPR, but every now and again it's a little bit different, and it might be construed differently. And I think how that plays out in the future is going to be interesting. But in relevant parts for today's purposes, I'm assuming it's all the same, and the UK and the rest of Europe has the same law in effect. So the types of claims that can be brought, the first type of claim might be brought under GDPR. A claim following a mass breach may be brought under Article 79, whereby each data subject has the right to an effective judicial remedy, where he or she considers that his or her rights under GDPR have been infringed as a result of the processing of his or her personal data in non-compliance with GDPR. There is, I think, an argument that Article 79's effective judicial remedy possibly doesn't include an award of damages. Neither the article itself nor the related recital, Recital 145, mention damages at all, whereas Article 82.1 specifically does mention compensation. And I think one has to look at those two recitals and those articles next to each other. It's just being interesting that they use slightly different language and maybe are looking at slightly different things. So if in the alternative Article 79 doesn't give a data subject a right to damages, Article 82.1 probably does. It does. Article 82.1 provides that any person who has suffered material or non-material damage as a result of an infringement of this regulation, namely GDPR, shall have the right to receive compensation from the controller or indeed a processor for the damage suffered. As an aside, different language versions of Article 82 talk of indemnity and indemnification as well as of compensation. And again, it will be interesting to see how that plays out. But rather than focusing here on whether the claim needs to be brought under Article 79 or 82, or I suggest both, I really want to note that there are two broad types of mass data breach. There's those where the controller is itself a victim of a data theft of some type, where it might or might not be itself infringing GDPR. It might have taken adequate measures to protect the data, or it might not have taken adequate measures, but it is the victim of a data theft. And the second type of cases, and I'll mention Lloyd and Google because Lloyd and Google is a potentially very important case in this story, where the controller does something with data that is in itself infringing GDPR. At its simplest level in Lloyd and Google type cases, the controller has failed itself to comply with Articles 5 or 6, and in some cases, that like those in Lloyd, where special category data is involved, Article 9 as well. So if you look at Article 82.1, the test for a claimant to recover compensation is if he or she has suffered material or non-material damage. And the concept of non-material damage is often key in these claims, which is what I want to look at next. The two places where the term non-material damage is used in GDPR outside of Article 82 is in the recitals, in recitals 75 and 85. So again, quite close to each other textually. Recital 75 states that the risk to rights and freedoms of natural persons of varying likelihoods and severity may result from personal data processing, which could lead to non-material damage, that phrase again. And then it says in particular, where data subjects might be prevented from exercising control over their personal data. So that's one definition of non-material damage. And recital 85 states that a personal data breach may result in non-material damage to natural persons, such as loss of control over their personal data. So I think that's where the English courts need to be focusing in terms of mass claims for data breaches, non-material damage, where the data subjects lose control over their personal data, and then working out what compensation under Article 82.1 needs to be. So loss of control, in answer, I guess, to your initial question, Anya, is the first area where data subjects might have claims against controllers under GDPR. And I also want to mention sections 168 and 169 of the UK's own Data Protection Act, which refers to non-material damage as including distress. And it uses the word including rather than being or comprising or is. So distress might be, but I don't think has to be, an element of what loss of control or non-material damage might mean. And that's what I'll call the GDPR claim or the UK Data Protection Act claim. And the second area of law that might come into play as a result of a mass data breach is nothing to do with GDPR, but is a tort, a civil wrong, the wrong of misuse of personal data. And that tort has played quite a role in quite a few cases, including most recently in Lloyd and Google, derives from more media type cases than data type cases, but this idea of misuse of personal information or misuse of personal data is a tort. And it's important to remember as well that although Lloyd and Google has now been heard in the Supreme Court and we're waiting for a judgment, hopefully sometime this year, the case actually was taken under the previous legal system, namely the UK's Data Protection Act 1998, which itself sought to implement into UK law the 1995 directive. So I'm going to say less about that tort, because whilst it has some basis in English law, I don't think it travels so well in terms of the new landscape in terms of GDPR, where loss of control claims, I think, ought to be equally available across Europe because of GDPR. And I say I don't think loss of control under GDPR and misuse of personal information, the tort, are identical claims. They look very similar, but one is clearly a creature of statute and the other is a judicial creation, a judge-made tort. One results in what's referred to as compensation, and the other results in damages. And I'm not going to address if there's a real distinction or not. It's quite easy for us lawyers to dance on a pinhead and get overly concerned. But I think that it's interesting, and I won't say any more than that, it's interesting that those words are used. And whilst there are clear rules in English law on damages, mitigation, and so on, I'll simply state that those might not equally apply to the statutory concept of compensation. And clearly there are future cases to be had that will decide that point. So that's the basis of the claims. And then how can a collective action be brought in the English courts? there are two possible routes in England, and neither of which is the Article 80 route, to which I'll briefly return. Article 80 GDPR I'll come back to in a second. So the rules applying in civil litigation in England are set out in the Civil Procedure Rules, the CPR, and 19.6, which is the Lloyd and Google route, is available for representative parties where all the parties have the same interest and the claimant has that same interest too. And that's the route adopted by Mr. Lloyd in Lloyd and Google. In essence, he is saying he's entitled to represent the whole class of claimants who are similarly subject to non-material damage in the same way as he says he was, and they all have the same interest. And it's an opt-out route. The advantage of the opt-out route is the cost of trying to build a class are avoided and make the process less front-loaded cost-wise. The other route for mass claims, collective actions, is 1910 of the CPR, the group litigation order or the opt-in claim. And these are expensive, they're hard to achieve in any meaningful number. You need lots of people claiming, which when the expected level of compensation or damages is relatively low per claimant, means the claimant funders, and there almost always will be funders involved in an action in the UK, would need to attract a very large number of claimants to sign up to the claim to make it viable. Just the upfront costs of advertising and signing up claimants are huge compared to the relatively low costs of a 19.6 opt-out route. The challenge for the Supreme Court in Lloyd and Google is whether to permit the claim to proceed, and so give the possibility of some justice for the claimants whose personal data has been misused or who have lost control of their personal data, or to reject the 19.6 route, and effectively that might bring a stop to data subjects exercising what are referred to at the very beginning of GDPR as their fundamental rights. If it's too expensive to enforce the right to compensation, there is no real right at all. The UK government decided a few months ago that it didn't intend to introduce an Article 80 route. The UK government said that it was mindful of developments in Lloyd and Google, and it said that the claim in Lloyd and Google demonstrates the potential for a form of representative action to succeed under the existing rules. So the government of the UK has acknowledged that there might be a 19.6 route to be had, and we wait and see where the courts end up. Of course, Article 80 is quite limited in that it allows opt-out actions or representative actions, but arguably not for compensation claims under Article 82. And if you look at the closing words of recital 142, you'll see that the problem one's got of Article 79 claims, Article 82 claims, Article 80 sitting in the middle, and the recitals not quite meshing it all together. So, but in any event, as Article 80 doesn't apply in England, I'll leave that to my EU colleagues to comment on. Anya, thank you.
Thank you so much. Next, we have Professor Ianika Tzankova. Ianika is a founding partner of the litigation boutique firm Birkway, which is involved in one way or another in most of the complex multi-party cases that are currently being prepared or pursued before the Dutch courts. She also holds the first European professorship in that field since 2007 and is involved in many international and European academic projects in the field, including the ELI, UNIDROIT, model rules on civil procedure, editing class actions in context. Ianika, thank you.
Thank you, Anya, for your kind introduction, and thank you for the invitation by BIICL. I've learned already a lot from my fellow panelists. I do not consider myself a privacy or data breaches GDPR expert. And the nice thing about these challenging and complicated topics is that they need multiple disciplines. They need a combination of disciplines to try to understand what's going on and to grapple with the challenges. And last week I was involved in another seminar that was related to the European Directive, European law and private international law issues. And there we needed a combination of European law lawyers, of proceduralists, consumer law. So thank you very much already for inviting me. Now, my short presentation of the Dutch situation will reflect my background in civil procedure, because with all due respect to my colleagues, privacy data breaches specialists, it may very well be the substance is all laid down in GDPR. At the end of the day, if procedure doesn't work, we end up with nothing. So let me give you the overview of the procedural take on GDPR from a Dutch procedural law perspective, and we'll touch later on the interaction with the European directive, so I will not go into much detail into that. But when it comes to data breaches in the Netherlands, first of all, one needs to make a distinction between data breaches and actions for data breaches against the government on the one hand, and data breaches against private entities, businesses on the other hand, because depending on the nature of the defendant or the infringer, a different legal protection, different route applies. And if your action is against the government or semi-governmental entities, because as we have discovered under COVID, that could involve quite a few data breaches, you need to follow the route of administrative court. Now, why is that important? For two reasons. First, because under the administrative route, there isn't really a proper functioning option of group or collective action. So it's basically, per definition, individual claim. Secondly, and that is a bit off the record, the highest Dutch administrative court has somewhat the, how should I say, the perception, gives the perception, there is a perception among lawyers, practitioners, that it is somewhat defendant/state friendly. So you prefer, if there is a way to bring such a data breach before the civil court, to do that, but it's very difficult because you need to demonstrate that the administrative route is lacking, so there isn't one, and all other formal requirements. I will not bother with details, but it is good to keep in mind that somehow the state and governmental entities seem to be better protected in case of GDPR infringements. Now, when it comes to the potential breaches, wrongdoings by private entities, as Adam pointed out, they are generally two groups of potential infringements. In that context, the one are the structural potential alleged data infringements that on which basically the business model of the company is based on, and the other group are the incidents, the one-time hacks or leaks that are structured, that is substantial enough to cause a substantial data breach. If we look at what has happened so far in the courts, both administrative courts and civil courts in the Netherlands, we do see that there is some activity. So on the side of administrative courts, we've seen complaints against municipalities or other governmental entities for data breaches, and some under the GDPR, and some have even been successful. The courts have awarded, the administrative courts have awarded small amounts, symbolic amounts, if you want, of between 200 and 500 euro for the infringement. On the other hand, if we look at the GDPR infringements, alleged infringement, that actions being brought before the civil courts, we see far less activity, but the activity that is there is substantial in terms of impact on the companies involved. So far, 2 collective actions have been filed under the new Dutch law, the Dutch Collective Damages Action Act, that came into effect by the 1st of January of 2020. The first one is against Oracle and Salesforce, and the second one is against TikTok just last week. That is like really a brand new action. If I'm not mistaken, there is also one under the old collective action regime, which is not for damages, but only for injunction, that is against Facebook. But the far more interesting ones right now are the two currently pending collective damages actions. Now, what is interesting about this new act that was introduced in 2020, it allows for the collective action for damages to be put forward by, as you know by now in Europe, non-profit organization. It could be a pre-existing, long-standing, established one like consumer associations, foundations, but it could also be one that has been established particularly for the purpose of this litigation. And that is the case with respect to the Oracle and Salesforce action. Interestingly, the action against TikTok has been filed by an entity that was already established in 2016 in relation to other areas of public interest, and only recently has also expanded its area of activities towards privacy data breaches. So we see organizations that started as ad hoc, if you would call it, or incidentally established, that exist a number of years, and then start to evolve activities in other areas. And you may wonder, are they still ad hoc, or have they passed that status because now they are out there for many years? So that is an interesting question. For purposes of being admissible in the Dutch collective action, it doesn't really matter, because whether you're ad hoc or pre-existing, you could be admissible if your articles of association are appropriately drafted, if you have sufficient funding capabilities, and if your governance structure is in place and there is a whole list of requirements that such entity needs to meet. If there are more competitors or frenemies who want to join you in the action, the court will need to appoint which is the better one. We have had some case law in other areas, not in these two cases, but in other areas where we see such case law, such situation emerging. We haven't had a case law yet where there were two really competing and, in a sense, of fighting for their exclusive representative position, but I'm sure that's just a matter of time. And I'm sure we'll also see such activity in the area of privacy and data breaches. And the action can be brought, and it's very interesting, on opt-out basis for claimants, data subjects domiciled in the Netherlands, and everybody else can join on opt-in basis, as is also the main rule under the directive, but also in other European jurisdictions. And after this, after the court has established admissibility of the entity, its suitability of the actions to proceed in collective fashion, we have a true, I would say, American style certification process. So I would say it's quite defendant friendly. And we get to the opt-in, opt-out stage, and we've passed that one. Then, interestingly, the court will not immediately get to the substantive review of the case. And that may explain my remark at the beginning when I said what may very well be for my substantive friends, substantive law friends, experts, but it might take us quite a while before we get there. And typically the court first will ask the parties after the certification stage to try to explore a negotiation or out-of-court settlement. And only after that fails, only then the court will move to review the substantive matter of the claim. By that time, in view of this very complex front-loaded certification stage, a lot of money would have been spent on both sides. So I think the hope of the courts is that then parties will work out something sensible. So no need to say we haven't gotten there yet. We are very, very much in the early stages of the proceedings, and we will have to see how this will play out. So I would like to leave it there, Anya, if that's all right, and maybe we can follow up with Q&As later.
Thank you so much, Ianika. And last but certainly not least, we have Dr. Vanessa Wettner, Vanessa is a very experienced litigator who represents national and international clients in complex dispute resolution matters before the German state courts and the Court of Justice of the EU. Her broad litigation expertise covers all areas of law with a particular focus on e-commerce, data privacy, and false claims trademark litigation, as well as commercial and capital market disputes, specifically shareholder class action litigation defense work. Vanessa has led one of the first mass litigation cases in Germany, defending a major investment bank against more than 1,000 investor claims. In recent years, she's become lead counsel in high-profile cases for a lot of US tech companies in data privacy litigation matters initiated by the Federal Consumer Protection Association or similar associations. Vanessa is counsel in the absence of GDPR preliminary proceedings pending before the CJEU. Vanessa, over to you.
Many thanks. And I also would like to thank everybody to have been invited to this webinar. I had prepared a presentation, but given that everybody is speaking without a presentation, I think I would prefer to go ahead without showing the slides and speaking freely on the topics. As a starting point, the situation in Germany is slightly different than in the other countries, because interestingly, when the GDPR came into force, even though Germany slightly adapted the German Data Privacy Act, no use was made of the possibilities under Article 80 para 1 and Article 80 para 2, i.e. the possibility to give power to specific entities to file damage claims for data breaches with a mandate of an infringed person, as it has been foreseen in Article 80 para 1. And even though it's unclear whether Article 80 para 2, which provides for a possibility to file for claims without a mandate, whether that specific provision also covers damage claims. As I said at the beginning, Germany did also not make use to adapt or introduce a provision in that regard. The reason being because before GDPR came into force, there was already a very lively activity of the German consumer associations, the associations who protected the interests of consumers. They are typically active under the German Unfair Competition Law Act and have filed various claims in various areas of law before the civil courts. As Ianika just put it, interestingly, in the data privacy field, the regulators in the past were much slower than the consumer associations, and for that reason also the administrative courts who were dealing with orders who have been issued by the regulators only came into play at a much later stage than the civil courts, which were already dealing with cases which had been initiated by the consumer associations. And as I said, under the German Act for Unfair Competition, it is clear, there's a clear provision providing those associations the right to file claims for injunctive relief without a mandate. So these associations are filing their claims in their own names. And as I said, in various areas of law, but also in privacy, with respect to data privacy breaches. And we were handling already a lot of these cases before the German courts. Most of them are pending in Berlin, where the Federal Consumer Association has its seat. And as I said, since they were very active, all these cases were pending. And then GDPR came into force, and suddenly in all these cases, the question arose whether the national provision based on which these consumer associations are active, whether that still gives grounds for their standing to sue after GDPR came into force. And the argument which is repeatedly being made, I mean, of course, typically on behalf of the defendants who are trying to get rid of these injunctive claims, they were stating that GDPR provides for a conclusive regime of enforcement, public enforcement on the side of the regulators, private enforcement through the infringed persons or the consumer associations to the extent that the legislator has granted them a right to sue after GDPR has come into force. And ultimately, out of the many cases which were already pending when GDPR came into force, the Federal Supreme Court referred one of the matters to the European Court of Justice last year, and referred the question whether these consumer associations who are typically filing injunctive claims for violation of consumer laws, such as the privacy laws, whether they would still be entitled to bring these claims after GDPR has come into force. As I said, the proceedings are already pending at the European Court. We are handling this case, and it's public that it's a case which concerns Facebook. Interestingly, the Austrian Supreme Court, the Federal Supreme Court, has in parallel or some weeks later filed a very similar referral question to the European Court. In the German referral proceedings, submissions have already been filed, and yeah, we are just waiting now for the hearing date, and are of course very curious to hear what will be the outcome and the view of the European Court with respect to these injunctive proceedings and the standing to sue, which has been granted by national provisions to consumer associations. While the proceedings at the European Court are pending, all national proceedings have been suspended, and interestingly, the consumer associations have also not started new proceedings. So apparently they are waiting for the outcome of these proceedings. So this is the area of injunctive claims. But as I said, the German legislator did not make use of the provisions which also provide for actions for damage claims. So what has happened since GDPR came into force is that merely claims by individuals have been filed for damages in various civil courts, lower courts, regional courts. Some of the proceedings went up to the higher regional courts, but within the last 3 to 4 years, there have been around 35 of these cases, and only 1/3, around 10 cases, courts have actually granted damages and a compensation. And I will come to that later on, but just as a starting point, wanted to let you know that as of now, no group action has been started for data privacy breaches in Germany. Which is interesting because even though there is no specific data privacy law which has been adapted after GDPR came into force, we also have civil procedural provisions which provide for mechanisms to file mass claims. And as has been said at the beginning, in Germany, the development was first that investor claims were the basis for these mass claims and have been litigated over the last 10 years. Typically cases for prospectus liability or other investment in decisions, but not as broadly as it is available now. Because 2 years ago, the German Act for Declaratory Action has been introduced, which now gives consumer associations the right to bring mass claims for any violation of consumer protection law. The law as such has been introduced in the course of Dieselgate. And so what consumer associations have done over the last 2 years is filing these mass claims, particularly in order to give compensation claims to Dieselgate well, victims, you can say. And since these cases are now coming to an end, we are certainly at a point where I would say it's for sure that consumer associations will now look into the possibility to bring these mass claims also in case of data privacy breaches. But as I said, this has not happened until today. And interestingly, even also in German literature, there is not a huge discussion whether these procedural mechanism can also apply to data privacy breaches. How does the procedure function if it would apply? I mean, actually, it's again only an action for a so-called qualified entity. These are in essence consumer associations which can bring these claims, and they are not bringing the claims in the name of the infringed data subjects, but they would bring the claim in their own name, but need to show that a minimum of 10 consumers has likely been affected by a data breach. And they would also need to establish that a minimum of 50 consumers has registered their claim with an online claims register. So it's a clear opt-in mechanism, which only has a binding effect if you have registered with the claims register in advance. And as I said, whether it applies to data privacy breaches is unclear. Other than in other jurisdictions, the procedural means for mass claims does not result ultimately in a judgment on an exact damage amount, but it will only have as a result a declaratory judgment. The procedure already starts at the level of the higher regional court and has then one further appeal to the Supreme Court. The action deals with specific questions on declaratory statements, such as, for example, has there been a data privacy infringement, or is causality been given for a specific group of data subjects in case of a data privacy violation, but it's not available to have the court rule on specific question on damage amounts. Actually, what will happen is that at the end of the procedure, there will be a declaratory judgment, as I said, which has a binding effect on all consumers who registered their claim, and then only afterwards all these consumers would need to file individual actions in order to claim their specific damage amount based on the binding ruling of the higher regional court in the model case procedure. As it has happened in the Dieselgate court cases, it is very likely that a lot of these cases, if they are being used because they have a very high publicity, of course, there is this public court register, and everybody can see that how many consumers have registered and what is at stake. In many of these cases, court settlement is probably a very good option for a company in order get rid of such a case and to avoid that more consumers are being registered. The civil procedural provisions also provide for a mechanism to settle cases. But again, if more than 30% of the consumers have registered opt out of the settlement, then the mechanism doesn't work, which means that no court settlement with a binding effect would be available. As you may have read in the news, the Dieselgate civil cases in Germany have been terminated exactly by this mechanism. So in the end, it was ultimately a court settlement, which has been reached for the consumers and which was in the end a much faster way to proceed an effective amount than claiming such a damage amount in an individual proceeding, because even though the court proceeding, which ends with a declaratory judgment, would not be available in order to rule out a specific amount of damages in a court settlement, that would of course be possible to enter various provisions which the parties deem necessary in order to settle the case. And last but not least, just a very short overview on these individual cases I mentioned, which have already been filed for damages in case of data privacy breaches. As I said, there were only around 35 cases within the last 3 to 4 years, and in only 10 cases, damages have been rewarded. Usually courts are very restrictive in granting compensation, and the typical scenario for a damage compensation is the violation of a general right of personality through the data privacy breach, which can then result in a reasonable compensation. And it's then up to the court to estimate what is reasonable in the specific case at hand. In the past, damage compensation have been granted in the range between 1,000 and 5,000 euros per individuum, so not huge amounts, but it is to be expected that likely the basis for the calculation of the immaterial damage amount or the amounts which will be ruled out by courts will probably increase. Interestingly, and this is the last point, just recently the higher regional court of Stuttgart has referred a case to the Federal Supreme Court on damage claims under Article 82 of GDPR, and in parallel, in a different case, which was first pending at a lower court in Germany and then went up to the Federal Constitutional Court. There, the Constitutional Court ruled that it is ultimately up to the European Court of Justice to define the specific criteria and basis for a compensation under Article 82. So it will be interesting to see how this case moves on in comparison to the case I just mentioned, which went up to the Federal Supreme Court, also on Article 82. So to conclude, Germany is slightly different, even though there is a procedural mechanism to file mass claims for damages for data privacy breaches. This has not yet been used, and it will be very interesting to see whether consumer associations will jump on this mechanisms once all Dieselgate scandal cases are being terminated and resources are free to get these cases filed. Many thanks.
Thank you so much, Vanessa. We have about 30 minutes now for the Q&A, though I think we could probably all talk for hours about all of the issues. Just wanted to make a couple of observations. one of the things I think is very interesting based on what we've just been hearing is that we start with the GDPR, which, as we all know, had as one of its major objectives achieving harmonization, consistency of outcome for data subjects across the EU. But based on what we've just been hearing, actually, we're looking really a potentially rather fragmented and dissonant picture rather than consistent outcomes for data subjects across the board. And that's obviously down to the very different procedural dynamics we're seeing in play in the different jurisdictions. I think there's also an interesting question as to who's driving this litigation. I mean, within the UK, in my experience, and Adam's as well, no doubt, it's really the claimant law firms and the litigation funders who are driving mass privacy actions. There are one or two cases that have been brought by representative organizations, but really the vast majority are being pursued effectively for profit-making purposes by claimant firms and claimant funders. And it seems that in other jurisdictions, actually it tends to be more the consumer associations that are driving things forward, which I think is really interesting and probably a product of kind of domestic legal culture more than anything else. Can we perhaps begin by touching on some of the points that Adam was raising about the sorts of damages that are being first claimed in these actions and second recognized by the courts in these actions? Because we've had this controversial development in the UK, talking here about the Court of Appeal's judgment in Lloyd at Google, whereby the court recognized loss of control in itself as a head of damage that is potentially compensable under data protection legislation. That's loss of control in the absence of distress. And I'm just wondering whether the other speakers from the EU jurisdictions have any thoughts about how that concept would be dealt with by their particular courts. Let's start with Maria José.
Well, there's no case law with respect to the compensation of damages in the data field breach in French courts. Judges do accept, however, to compensate the so-called moral injuries, that is to say non-material damages, which include several aspects such as pain, suffering, loss of enjoyment, and one could add loss of control today. The acknowledgement of this head of laws is related to a major case law principle in the French jurisdictions, which is the full compensation one developed by case law. And this means that the claimant must be compensated of all its damages, but only the damages suffered. That is the reason why there are no punitive damages under French law. As any damages claimed, non-material damages must be certain, personally suffered by the claimant, which here will be the group represented, and a direct consequence of the alleged breach. This is Article 1240 of the Civil Code. But there is no particular requirement in terms of type of evidence to answer to the questions that have been asked in the chat to provide for in the courts. Judges decide on a case-by-case basis and compensate such damage even when the file includes little evidence. Nevertheless, the amounts of compensation are generally not significant. Another head of non-material damage in the French case law corresponds to the so-called anxiety damage, préjudice d'anxiété, defined as the fear to suffer from a damage in the future. First limited to the asbestos-related claims, the French Cour de Cassation has extended it to people having been exposed to any toxic or novice substance in the field of medical devices and medicines. Scholars state the average amount granted would be around 8,000 euros based on the analysis of case law. And the French group action by the association Université que choisir against Google, whereby she claimed 1,000 euros per person, must have been claimed on this basis, I mean, on this head of laws.
Thank you so much. It's interesting, we often talk about the damages being small, but the question is, from whose perspective are you judging that issue? Because for sure they may be small, judged from the perspective of the individual data subject, but when you scale it up across the entire class, which can be in the millions of data subjects, if not tens of millions, then you're looking at vast and potentially completely annihilatory damages that the controller will have to pay out. And I think it's a really interesting question about whether when judges are deciding these fast class cases, and we're similarly in a position in the UK where these cases haven't got to a quantum hearing to date, but whether the court will have in mind that scale question when it's thinking about, first of all, whether to let the action through at all, and second, if it does let the action through, how it quantifies the individual claims. That's perhaps an issue we need to come back to when we talk about the separate theme of how the courts are going to set about quantifying these claims. That was really interesting. Ianika, do you want to come back on this question about the types of harm that can be, or types of damage that will be recognised by the court?
Yeah,
whether it's a pure loss of control without distress?
Yeah, I was just thinking on the comment you made. I totally agree with that. It was actually something I wanted to point out, that it really makes a difference whether we are talking about individual case calculation of damages, or whether we're talking about calculation of damages in the collective action context, because then you have a whole different dynamics, not just in terms of the aggregation, but also how do you prove that, right? what do you require? So far, we haven't had court decisions where this question has been answered on aggregate basis. So I can only speculate based on what we've seen so far in individual cases, how I think the courts may approach this question in the aggregated format and setting. And we have had a Supreme Court judgment a while ago with a very interesting annotation of a well-known law professor who was very recently appointed Attorney General to the Supreme Court. So that is kind of gives us a little bit maybe a sneak preview of what he might be advising the Dutch Supreme Court on this topic. In his case note to this Supreme Court judgment, he made a very interesting analysis and pointed out that in these type of cases that involve the infringement of human rights, the mere fact that the human rights has been infringed should be accepted as leading to a damage. And in this type of cases, the emphasis should be on the nature and the impact and the duration of the infringement rather than on the actual what it has caused. So the mere fact that the human rights infringement has taken place kind of presupposes that there are severe damages. I am not sure whether everybody equally emphasizes this approach. I personally find the UK approach of loss of control of data that transforms into a economic value much more interesting. But maybe because I see myself less as a human rights lawyer and more as a legal realist, because I think it is this profit-making character that motivates companies to behave in a certain way. So I think approaching the damages theory from the point of losing control over your data that has a certain aggregated value, that appeals much more to me, and I think it's much more in line. But then again, we don't know, we haven't seen that yet. And somebody asked, I saw in the Q&As, if you allow me, I need to pick up that question because we are talking about that now anyways, whether I think that European courts will follow Dutch court judgments in how they approach calculation of damages, etc. It's obviously very hard for me to comment on German courts or Spanish or Italian. But if we focus for a moment to the Dutch courts, I think the Dutch courts do have a tradition of open-mindedness, of comparative approach to important legal themes like the wrongful life, wrongful death, which is an entirely different theme, but it's just to show that they feel comfortable and incorporate in their case law comparative elements. We also have seen in the competition area that Dutch judges are sitting as observers in UK case management hearings that are on the same type of cases, and this is the same type of follow-on cases. So that tells me that there is this open-mindedness of trying to be pragmatic. That is what Dutch courts are known for, being pragmatic, and also look at what is happening elsewhere and how does that fit in our culture, but does it also make our life as judges and as society easier, because it helps us to grasp with the challenges of these type of cases. So I do think, the short answer, I do think that the UK case law might have an influence on Dutch courts. I do think so.
Thank you, Ianika. I'm conscious we've only got 15 minutes and we're still on the first question. But Vanessa, do you want to quickly come in on, because this is such an important point, you know, what type of damage is compensable is so central to what we're all grapple with. So Vanessa,
I'll make it short. I mean, as I said, the courts are still very hesitant to grant damages. When they have granted damages, they have also assumed a loss of control of the data, and the threshold was in these cases rather low. So the courts have said that if that can be shown, and I mean that should be easily shown, then there is a data privacy infringement and damage can be granted. Interestingly, the factors that courts have taken into account when determining the exact amount then was typically the nature of the violation, the duration of the violation, its severeness, potential or actual negative effects for the data subject. Also, the turnover of the data controller can be an aspect. And of course, the degree of fault and actions to be taken to reduce a caused damages. So it's a mixture of various factors, and in the end, it's the court who can decide which factor is the most important one. But I think that already gives at least a starting point for the calculation topic.
And just to finish off the point, one of the things I think that makes the loss of control head such a controversial head of damage, certainly in this jurisdiction, is it effectively proceeds on the basis that the claimant or the representative, if it's a representative action, only has to prove breach. Because if there's breach, there will be loss of control. And that the claimants themselves don't have to prove any harm. The more ordinary variety is like, the breach occurred, it caused me to suffer distress, and I have to prove not only that there was a breach, but also that I've suffered distress or pecuniary loss. And so the concern is that if you remove the requirement for claimants to have to prove harm, because all they have to prove is breach, you get to effectively completely disproportionate outcomes that, you know, do not accord with a sort of pragmatic approach and proportionate approach to this legislation.
I guess the flip side, and I appreciate often when you and I are speaking, we're sort of coming at it from different perspectives, but actually I sort of act for claimants and defendants. I see it from both sides. But if there isn't a right of action that you can claim when the controller has willfully chosen to misuse the data, they've effectively had a sort of a cost-free profit. And there's a significant imbalance between the controller on the one side that has taken the data for its own purposes, and the consumer who is atomized to a relatively sort of tiny position. So unless you do have the possibility of funded class actions to be a countermeasure to the actions of the, and let's think of say Google as a sort of a mega corporation that's got the ability to defend itself, but also chose not to pay to take the data in a Lloyd and Google type claim. I think you've got a significant imbalance going on in legislation which is designed to protect data and to go back to Ianika's point, a human right, a fundamental right to the consumer. So I get exactly where you're coming from, Anya. I do understand that concern, and that's sort of goes to some of these other questions, is how is the court going to quantify the compensation? But probably some of the calculation it needs to take is probably to borrow from other areas like IP. If you've got an account for profits or something, looking at what was the profit I made given I didn't pay for it in the first instance, and I suspect there's some sort of equitable and economic answer to be had. But I get the counter argument that it's a disgrace for claimants to bring these cases, and I also get the argument that this is just for the benefit of the funders and the lawyers.
Yeah, look, I mean, there's so much there that we could look to discuss, including whether, you know, regulation is the answer to the problem that you're outlining, and indeed whether we want to really be moving in the direction of treating personal data as a type of property that engages similar considerations that you have arising in the IP context. But let's move on to a related issue that I know a lot of people in the audience are really interested in, which is how do the courts set about quantifying the harm, the compensation that represents a notional value for the harm that's been suffered? I mean, there's been very scanty jurisprudence in this country, none of it arising in the context of class actions. But I'm interested in hearing about how matters stand in Europe. We've had Vanessa talking about the courts adopting a restrictive approach. And I read recently there have been some recent German court decisions where actually they dismissed the action altogether, effectively because it doesn't cross the seriousness threshold. But Maria, José, do you want to come in on the question of how the French courts are approaching quantification? I mean, I guess it's an issue for you because similarly, you haven't got to that point either. But is there anything in the sort of French jurisprudence that you think helps?
No,
French courts would approach the issue.
Indeed, as I said before, there's no experience at all when it comes to collective redress, and when it comes to individual redress. We have, on the one hand, a decision having granted 250 to a person whose data have been wrongly included in an application by the doctor. And we've had, on the other hand, 8,000 euros on these devices and medicine cases. So no experience at all, but what I would like to stress is the importance of public authority decisions and the sort of follow-on collective redress that we could think of when it comes to having the criteria to assess the amount of the damage. For instance, when the French authority fines Google 50 million euros, she gives important information for an eventual collective redress that might follow on. So, well, like in the competition sector, I think the data breaches might develop this type of follow-on collective redress.
Well, I can say that's already happening in the UK with lots of claimant firms waiting to see what the ICO is going to do with a particular incident, and if a penalty notice is issued, then you can be sure that in their particulars of claim they will be relying extensively on the reasoning in the penalty notice. So that's definitely happening here already. Ianika, do you want to come in on the quantification point?
Yeah, it's just a short note because I already said quite a lot about that, but I realized while listening to Adam that I didn't mention what was in the instruction for our short initial opening statements about the causes of action in the Netherlands, because that actually reminded me that we do have, via the different types of cause of action, maybe also different approach to the damages calculation in the context of collective redress. So we have, so far we've seen three causes, potential causes of action. The first one is based directly on the GDPR, so that is, not really new. But the second one is a statutory tort that could be also could serve as a cause of action. And the third a cause of action that we've seen in one of the cases brought as collective actions is the unjust enrichment. Now, the first two causes of actions, the GDPR one and the statutory general tort, would very much have, the same issue that we just discussed. Are you assuming, like what has happened in a few cases right now, that the mere fact of human rights infringement supposes some type of action, and then the courts simply follow? We have these guidelines about immaterial damages, which I'm sure you have as well in your jurisdictions, that identify if you lost an arm, or if someone said something bad about you, that is how much that's worth. So this is what we see right now, without the claimants having to actually show, this is my meds GP's prescription, I had sleepless nights, and for a week I was just outraged and embarrassed, and I slept at home with my curtains closed. This isn't the kind of evidence you need to submit. But then if your cause of action is unjust enrichment, one could imagine that then different calculation methods come into play, and that we would need assistance from economic experts and to quantify the amount of the enrichment, which then is a second question. Once you've determined that, how do we make sure it is being distributed right among the class? So we're not there yet, but these are the issues that we are coping with right now.
And if you want to just come back on the English law approach to damages, as we've seen it emerging outside of the class action field in respect of privacy claims.
Well, I think there have been various sort of approaches, quite often in the sort of media to privacy space, and we were particularly talking about those cases earlier, which have had an influence on the way one's viewing these privacy claims. But I think the idea that there is a sort of a scientific approach to how you calculate it is far-fetched. It's very hard. A Martian looking down from a great height at what's going on wouldn't be able to discern a pattern of anything going on. I think there has been a tendency to higher privacy type, to media type privacy damages than previously, and then you get a whole bunch of cases where it's reduced again. I don't think there's much that I could point to. The very, very limited number of data protection cases have resulted in very low awards, but I think, again, as long as it meets a certain threshold, and the test will be, what is that threshold, one should be able to make a claim. The other thing, if you don't mind, I was just going to comment on, which is possibly a difference in the UK position and the European position, is the adverse costs consequences of bringing an action. So the claimant has to be well funded to be able to bring a claim against a large defendant because of the risk of an adverse costs award. And I think that's, again, part of the sort of the calculation in this sort of game theory of how much money do I need to put in and how much money might I get out, because I might lose. And I think that's something which my experience of dealing with certain European jurisdictions and courts hasn't played out in the same way, and therefore I can see why, irrespective of the regulatory framework of allowing funded litigation or not, the cases are slightly different and brought in a slightly different way, and there's probably some learning from each other in that regard as well, because again, you've got the large defendant and potentially the individual not being able to pay.
Vanessa,
I don't know if you, Anya, if you wanted to say something about sort of damages.
I was going to say that generally what's regarded as currently the leading data protection case is a case called TLT, where the court adopted very much the approach that you've just outlined, Ianika, which is treating sort of personal injury cases as a sensible analogue for calculating damages. So in that case, someone was put in fear of their life as a result of the publication of information by the Home Office, and they got £12,500. And that's seen as sort of the high watermark, the worst kind of distress case you could have, and it's worth £12,500. Obviously, that's a huge amount of money, though, if you're looking at a case that's a mass case. even though it doesn't seem like a great deal of money if you've been footing for
but the maths is very simple. If you've got even a relatively small amount, 200 pounds, say, and 1 million claimants, you've got 200 million pounds worth of damages. And if you've got 10 million claimants, 2 billion pounds, it's sort of, the maths is very easy to do. And you only need a small starting position if you've got a big number of people. But I guess that's what we're talking about, is mass data breaches.
Yeah. Vanessa, do you want to come in on this important point?
Well, maybe just one point Adam just raised. I mean, I think it's indeed a different approach that Germany and maybe also the other European jurisdictions are taking, is because the fear that there is a class action industry in Germany, as we have it in the US, is so big that is exactly the reason why, for example, plaintiffs' actions are not yet, and I doubt that they will be accepted for mass damage claims. It's only these consumer associations who are funded by the state typically, and where also the dispute of the matter in the value of the matter in dispute has a threshold. So there are very severe restrictions on the situation you are describing for the UK. And it will be interesting to see whether with the European Collective Redress Directive, which goes far beyond what is currently available under the German procedural mass class means, whether the landscape will shift. Because then it's not a declaratory action, it's rather a real damage claim action, which can be filed. So that will be interesting to see. And maybe that's the reason why Germans are still hesitant to file their actions at the moment.
That also adds, I guess, to the competition between English courts, and I guess we would see the Dutch courts as being in competition with the English courts. But if you get that directive through, and we don't have that directive because of Brexit, it will just add to the competitive tension between the UK and the European Union.
Yes.
I'm conscious it's now 6:30. I've got a million other questions that I would like answered, but Duncan, I don't know if we have to draw it to a close there.
We probably have to. It's been as you said, Anya, it's been a fascinating tour d'horizon of all these issues. There's many things, I think, as you say, there's many things that that are going to be interesting to follow. And it's watch this space. So maybe we should reconvene in a few months' time and reconsider the cases. So I'll hand over to you, Anya, maybe to wrap up. Thanks very much for everyone.
Thank you so much, everyone. I found that really fascinating. One gets so sort of blinkered and obsessed with one's own tiny little parochial world. It's really interesting to hear what's going on across the channel in all these different jurisdictions. And I think we all have a great deal to learn from each other. It's a pity we have to draw this session to a close now. So I just would like to thank all of the speakers. Thank you so much. It's been really, really fascinating.